You know, it's not my style to criticize people in the conservative movement, and I'm not going to do it in this video by name, but I will say that there's a group of people out there that are very angry with Supreme Court Justice Amy Coney Barrett, and I think that's really not warranted and arguably a big mistake from the perspective of saving our Second Amendment rights and our Constitution. Let's break all this down when we come right back. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards, and for all of you who supported me for that great honor. All right, guys, we have to talk about Justice Amy Coney Barrett. You know, it's not my style on this channel to kind of criticize and comment on other conservatives and other Trump supporters and the like, unless I really feel the need to do so is super important. And this is an exception to my general rule. What I'm about to say in this video, I believe it's extremely important that we not mess this up. And I think there's some people that are in good faith making criticisms and arguments about some of the jurisprudence and decisions of Supreme Court Justice Amy Coney Barrett. Now, I have comments and criticisms about every judge in America and every Supreme Court justice. There is nobody that's perfect. I mean, Clarence Thomas and Justice Scalia did not even agree all the time. So disagreements is part of the legal process and part of being a Supreme Court justice and part of being a Supreme Court justice observer as well. But I want to say that these criticisms of Justice Barrett, in my view, are off the mark. And I want to talk about why I believe that's the case. I then want to explain why I think there is a little bit of a disconnect between the reality of Justice Amy Coney Barrett's jurisprudence, which is quite good, versus sort of perception of it in some quarters of the media. And last but not least, I want to point out why I think it's an extremely bad strategic idea from the perspective of the conservative Trump supporting movement, if you will, to attack Justice Barrett in some unhinged, crazy kind of way. So let's walk through the different issues. To begin with, let's think about where we are with Justice Barrett. So she was confirmed at the end of 2020. We're now at the start of 2025. And let's just hit the highlights of Justice Barrett's jurisprudence and her decisions. And let me ask you this. If back in 2020, when she was nominated and then confirmed, if I gave you this list, would you, as an originalist, as a conservative, as a Trump supporter, as a supporter of the Constitution and the Second Amendment, would you be happy with the list I'm going to give you now? Okay, let's begin from the top. Justice Barrett voted to overturn and voted and did indeed overturn Roe v. Wade with the Dobbs decision. Justice Amy Coney Barrett ruled in favor of the Second Amendment in a powerful way as part of the majority in NYSERPA versus Bruin in 2022. Justice Barrett reaffirmed that methodology in a very powerful decision of Rahimi, while ruling against Zaki Rahimi specifically, re-embraced and reaffirmed the very helpful Second Amendment methodology of Heller and Bruin again, and Rahimi. Justice Barrett did that as well. Then Justice Barrett voted with the majority to overturn the bump stock ban that was issued by the ATF years earlier. Again, no bump stock ban in America, in part because of the vote of Justice Amy Coney Barrett. Then we have Justice Amy Coney Barrett voted to knock out race discrimination in the form of racial preferences or affirmative action in both state schools, in the North Carolina case, the University of North Carolina case, as well as private colleges in the Harvard case. Both decisions supported by Justice Barrett. Then we have Justice Barrett voting to knock out the Chevron doctrine in the Loper-Bright case. Then we have Justice Amy Coney Barrett ruling for President Trump in the 14th Amendment ballot access case of Trump versus Anderson, which was where the Democrats and the liberals tried to knock him off, meaning Donald Trump, off the ballot for the 2024 presidential election by arguing he was an insurrectionist and thus he could be knocked off the ballot under the 14th Amendment. Amy Coney Barrett, Justice Barrett, ruled for Donald Trump. And then, of course, in a huge ruling in the Jack Smith attack and prosecution against Donald Trump in the presidential immunity fight in the summer of 2024, again, Justice Amy Coney Barrett ruled for Donald Trump against Jack Smith and against Merrick Garland in that presidential immunity case. Now, if I told you at the end of 2020, these were the decisions that you would be guaranteed to get by the justice nominated by President Trump, you would be very happy. Now, with that record, that is a fantastic record. That is a great record. Those are the big ticket items. And so far, Justice Barrett has done fantastic on these big ticket items. Now, let's talk about where there is some disconnect and where I think there's a misperception. And there's some legitimate criticisms about certain things about Justice Barrett, Justice Roberts, right? I'm not here being Pollyannish. You don't come to this channel for rainbows and unicorns or one particular view or one particular thing. I try to tell you where we are in the world today of constitutional law, where we are in the world today of the Supreme Court, and how I think we can best strategically advance the ball of protecting our Constitution, in particular our right to keep and bear arms, because without the right to keep and bear arms, the rest of the Constitution, in my opinion, the rest of our republic does fall by the wayside, which is exactly what early Supreme Court Justice Joseph Story wrote in 1833, calling the right to keep and bear arms and our armed citizens the palladium of our republic. So with that said, where is there this potential disconnect between the criticisms we're seeing on X and in some of the blogosphere and in some of the conservative commentators of Justice Barrett, where I think we really are? And I think this gets into the issue involving the so-called shadow docket. Now, what this means, the shadow docket is kind of a dark, scary term that the sort of the anti-originalists, the anti-Supreme Court, meaning the liberals, came up with to try to discredit decisions by the Supreme Court on cases, on issues that had not been fully briefed. And what do I mean by that? As you know, the traditional way the Supreme Court decides a case is they grant cert to a case, and then there's major briefing in the case, back and forth by the parties. There are amicus briefs submitted. There are dozens of them in many cases. The Supreme Court and the clerks read all these things. They then have oral argument that goes on for an hour, sometimes 3 hours, to get to the bottom of the issues. And then they spend several months writing opinions and dissents and commentary, whatever you want to call it, concurrences. And then by the end of June of every year, they issue these very long decisions with hundreds of footnotes. Some of these decisions go on for 100 plus pages. Now, the reason why I say that is a very long, normal process with a lot of thinking, a lot of considerations, a lot of navel-gazing in a sense, like where does this case go, the good and the bad and the ugly, for this part of the law as well as other parts of the law in terms of the tapestry of American law. Because I've taught you before that every single Supreme Court decision impacts the rest of American law in one way or another. It all connects, and the Supreme Court justices in particular have to focus on how one decision they make today will have a ripple effect on the rest of constitutional law. The metaphor I've often used on this channel is a spider web. It's a big spider web American law, and if you pull one single strand on that web with a particular Supreme Court case, the entire web moves somewhat, and the justices have to figure out ahead of time when they make that decision in that one case, how does it move the entire spider web of American law, even though they're only pulling a single strand with that one precedential setting case. Now, with that said, that gets into where there, I think, is this disconnect with the shadow docket. But the shadow docket it's basically a reference to all the decisions that are somewhat substantive that the Supreme Court makes other than through that long, laborious process I just described. These are cases that are rushed to the Supreme Court on an interlocutory basis in many instances in the middle of a case, asking for emergency relief from an injunction or for the issuance of an injunction. And this is done in a rapid way. Now, here's my suspicion, a little bit of speculation on my part. For those people that are experienced trial lawyers and litigators like I am, doing things super fast and making very big decisions really fast is kind of what you do. It's sort of where you make your money. It's where you make your living. It's kind of what you do for your profession. So you're used to turning briefs around and making decisions and writing things super fast and getting major documents out the door in a matter of days, maybe a few weeks, but you're really fast. This is in contrast, and you're going to see where I'm going with this in 1 second. This style of litigation and legal work is a dramatically different approach than one sees in law professors, academics, intellectuals. Why? Because if you know any people that are law professors, intellectuals, academics, you will find if they're professionals and it's what they do full time, they are sort of much more contemplative, more deliberative. Doesn't mean they're smarter, by the way. It just means their approach to answering questions tends to be a little bit more, shall we say, long form, long drawn out. They want to write a law review article. It takes them many, many months. Sometimes it takes them over a year. As they write the article, they share it with their colleagues. They rewrite the article. They share it with their departmental friends. They present it at a conference, and then they rewrite it. You see what I'm saying? There's this long process. And they don't like to rush documents or law review articles out in public rapidly. They'd rather take their time and do one powerful piece of scholarship, and it may take them many months or even a year or more to get that done. Now, Justice Barrett comes out of that world of academia. Justice Barrett, after she clerked for Justice Scalia, prestigious clerkships, she was an academic. She was a professor. And then from her professorship, from being a very powerful academic, she was elevated to the United States Court of Appeals for the 7th Circuit out there in the Midwest. So I only mention this because if you want to draw the bulk of the criticisms, as I see it, about Justice Barrett are in these decisions dealing with the shadow docket, where they're not decisions that are made after a long, drawn-out process of many months of analysis, where you got argument in October, a decision comes out in June, which you get in some big cases. You see criticisms of Justice Barrett being maybe more cautious than other justices because in the shadow docket context, you're often dealing with a much more rapid-fire style of decision-making where, cases come to the U.S. Supreme Court having been only litigated for a few weeks or a few months. They're on an interlocutory basis, which means they're not complete. There's no final judgment, and the justices have to make these snap decisions, and they don't generally like to do this, but sometimes they have no choice because the parties come to the court demanding some sort of relief in an emergency basis, and the justices have no choice but to act. In that context, I do think that Justice Barrett is the kind of justice that doesn't like to make those kind of fast snap decisions. I think she much prefers the long style of many months of analysis, which is a little bit more analogous to the lifestyle or the professional life of an academic. Now, to give you an example of just because there's a decision that we may disagree with rapidly on the shadow docket doesn't necessarily mean that we lose the issue ultimately. Just to give you one of many examples, let's just take the bump stock. As we know, the bump stock ban occurred during the Donald Trump first administration, his first term, and ATF issued a ruling that said that bump stocks were the equivalent of machine guns and therefore were banned. This occurred in 2019. There was a series of litigations, emergency applications for injunction, all the way up to the United States Supreme Court. And in 2019, listen carefully, in 2019, the Supreme Court on that shadow docket, on those emergency injunctions, refused to stop the enforcement of the bump stock ban by the ATF. That occurred in 2019. But as we all know, in the summer of 2024, guess what happened? The bump stock ban was found to be unconstitutional, to have violated the authority of the ATF, meaning it went beyond the authority of the ATF in promulgating it, and the bump stock ban was declared unconstitutional and struck down for all intents and purposes. So that's a classic example of recent memory that many of you probably know of, that in 2019, on the shadow docket, on the emergency basis, the court says we're going to let it go into effect. But the reality was, at the end of the day, after there was a lot of consideration, guess what happened? It was knocked out. And I think that we're going to see a lot of that now, where in the short term, we may see cases on the shadow docket or in these rush spaces or on these sort of super duper fast tracks may give rise to some decisions that we in the conservative community may not like initially, but that should not be taken as we're going to ultimately lose the issue. This issue dealing with Elon Musk, Doge, and USAID is an example of this, where the court, and there's a bunch of reasons, I went over this in my video yesterday, but there's a bunch of reasons why the court itself did not feel the need to issue an administrative stay of really a defunct TRO that was no longer in effect anyway, but they decided not to do that administrative stay and just sent it back down to the lower court to handle the court case in the normal way with the preliminary injunction hearing and go from there. And again, that's not telling me anything about what the Supreme Court is ultimately going to do on the merits. But a lot of people in response to that were very angry with Justice Barrett, claiming that she was the worst pick ever for Donald Trump and all this other nonsense, which is simply not true. For, among other reasons, the list of great wins that we in the legal community have seen, in part because of the work of Justice Barrett. I already listed it at the start of this video. Now, on this channel, as you know, I like to talk about how I think we in the Second Amendment community, the Trump community, the conservative community, whatever you want to call it, can win in the courts and can win generally. That's what I talk about on this channel. That's why you tune in, okay? So I want to issue a warning, and this is not a criticism of people that have good faith arguments against Justice Barrett and the Supreme Court. That's fine. But I want to give you a word of warning here. It is well understood in the Supreme Court bar community that one of the concerns we have is that Supreme Court Justice, the late Supreme Court Justice Sandra Day O'Connor, who was the first Supreme Court nominee by President Ronald Reagan, over time became a lot less reliable and a much more squishy kind of, went from like a law and order conservative type to kind of a semi-reliable liberal vote on a lot of issues. Now, there's a lot of criticism about Justice O'Connor, but there's a lot of people that believe that one of the problems was that Justice O'Connor was embraced by the left-wing media. She was heralded as this wonderful, great intellectual, and at the same time, some of the pointed criticisms in legal decisions by Justice Scalia may very well have contributed to shoving Justice O'Connor to the left against being an originalist and all these other things. Now, again, it's a totally different era when Justice O'Connor was around than it is today. My only point being is that it's fair to criticize public officials. It's fair to criticize decisions. That's acceptable. But I don't think it strategically makes sense for the conservative movement to over-criticize unfairly any of the justices, including Justice Barrett. And I want to give you this word of warning. The other side, the liberals in America, know how to play this game. They know how to get justices to evolve to the left. They know how they took David Souter, a lawyer out of New Hampshire, and get him to evolve where he became a reliable liberal justice. The same with John Paul Stevens, a Republican nominee who was, at the end of the day, a reliable liberal vote, including one of the dissenters, along with Souter, in the Heller and McDonald cases, ruling against the Second Amendment, for example. Now, the left knows how to play this game well, and they're already trying to play the game now, trying to woo, if you will, Justice Barrett over to their perspective by complimenting her, by, saying how great she is. They're trying to get her to flip, if you will, from being an originalist, someone who was a Scalia clerk, and turn her into someone that is evolved to the left. Now, let me give you just an example of this. Over the summer of 2024, there's an article by a prominent left-wing lawyer, very well respected by the name of Stephen Vladeck, who's written some good work and does a good job on covering the Supreme Court and legal issues. He's a liberal. He's on the other side of the political spectrum than from where I am, but he's smart and a serious player and well respected. And here's what he wrote in the New York Times, which in my view is the kind of thing we're seeing out of the left to try to woo Justice Barrett over to their team slowly but surely. Here's what he wrote this summer. When the Supreme Court term began last October, one of the more intriguing predictions from the commentators was that Justice Amy Coney Barrett, entering her third full term on the court, would come out of her shell and emerge as the court's new swing justice, casting the decisive vote in the most divisive cases. The commentators got half of that right. There's little doubt in looking at the oral arguments the court has conducted and the decisions it has handed down over the past 9 months that Justice Barrett has found her voice and has easily become the most interesting justice. Her questions and argument are penetrating. The analysis in her written opinion spares no one in its detail. See where this is going, folks? The New York Times, a prominent left-wing commentator and lawyer, is referring to Justice Barrett as the new swing justice, making the decisive decision in these huge cases. The most interesting justice. Her questions argument are penetrating. The analysis in her written opinion spares no one of its detail. Do you see? See where this is going, folks? The left is trying to woo Justice Barrett to become a liberal, to get her to evolve. And there's no reason for this, folks. There's no reason to think this is going to happen. To me, there's not a great concern. The record I just gave you involving the Second Amendment and Bruin, overturning Roe v. Wade, knocking out the bump stock, knocking out affirmative action in private colleges, knocking out affirmative action in public colleges, knocking out the Chevron doctrine, protecting Donald Trump in the ballot access case, ruling for Donald Trump in the presidential immunity issue, and so on and so on. But be warned right here and right now, conservative commentators that are out there on X, that are out there with your blogs, that are out there trying to get clicks, that are out there trying to get followers and subscribers. That's fine. No one's going to begrudge you of that. I'm warning you now, though. Pushing anyone too crazily in an unfair, insane way is not good strategically. Justice Barrett, who I'm not particularly concerned with, but Justice Barrett is going to be on the Supreme Court for the next 30 to 40 years, whether you like it or not. And I'm not saying that she's going to be swayed by anything you say on X or anything I say on this channel or anything Stephen Vladeck says in the New York Times or otherwise, or anyone else for that matter. But the reality is, it is stupid, in my opinion, to try to hammer Justice Barrett for all the things that you disagree with. Because I can find criticisms of every single Supreme Court justice right now that I disagree with. That includes Justice Alito, Justice Thomas, Justice Gorsuch, and so on. No one agrees with all of us all the time. But do not let the perfect be the enemy of the good, as they say. And with a record that Justice Barrett has provided so far, and I think that will continue to improve, I don't think it's going to go backwards. It is dumb strategy. It is stupid, in my opinion, to try to attack Justice Barrett in any kind of an unfair way. That doesn't mean you can't criticize her jurisprudence or disagree with her opinions or make legitimate arguments about her. But to somehow go out there and claim things like, this is the worst decision that Donald Trump ever made, this is the worst Supreme Court justice ever, that is silly. Because if you want to see terrible Republican picks for the Supreme Court, Earl Warren was a Republican pick. John Paul Stevens, David Souter, Justice O'Connor for that matter. On and on and on. Lots of terrible picks. Justice Barrett in no way, shape, or form falls into that category of terrible picks. In fact, so far, she's been a very, very good pick. And I see no reason to think that on the big ticket items, when cases go their full length to the end of the race, if you will, in big time cases where you got lots of months and real decisions and real opinions outside of the expedited shadow docket, I see no reason to think that Justice Barrett will not continue to follow the law, to follow the Constitution, to be a strong originalist in terms of her jurisprudence, and to make the late Justice Scalia, her former boss, proud. All right, folks, so there you have it. Hope you enjoyed today's show. Make sure you follow me on X, @4boxofdiner. Don't forget to subscribe both on Rumble and YouTube. We're trying to get to 200,000 subscribers on YouTube. And again, I appreciate your support. And we'll talk to you again really soon, again, here at the 4 Boxes Diner.
Orders up. Table 2A.